let us take this example forward, my lord. This is an unstamped document. I'm the arbitrator. I will simply say that this is an unstamped document. It can't be stamped. I will not take it into account at all. If you voluntarily produce it, have it stamped, we go ahead. But that is a decision, my lord, to be taken by the arbitrator and the voluntary nature. Please see what happens in NN Global. You are forced to produce the document. You are forced to pay 8 lakhs, which you say you shouldn't pay, and your bank, and it is impounded by the registrar, and your bank guarantee goes. My lord, this is the implication. If today in 11, your lordships are to decide all the issues which my learned friend said, how much is the stamp duty, who is the right party, who is to bear the amount, etc., even albeit on a prima facie basis, my lord, I would respectfully submit that the door would be a little wide open, which perhaps, my lord, was not really the intention. My lord, I'll just show, my lord, I would put it in a different way. Your lordship says, is it a court to receive evidence? Or I would say that it is not a court to receive evidence in that sense. It's a summary court which can take within its fold even a photocopy, of course certified. So, my lord, whichever way your lordship looks at 33, and it's a fiscal statute, it has to be read strictly. If I can get out of it, then it's between me and the government. Then it is, the court will not go overboard to protect the government. It's a fiscal statute. It has to be read strictly. If there's
a tax collector,
sorry, Manoj, court is
not become a tax collector.
So, Manoj, before the arbitrator, the original will be called for. It has to be called for if you want some substantive relief. And if it is not, the arbitration will end.
That constitution bench
right.
About
what I have done is, Manoj, there are. Karamchand. What I have done is, there is one judgment of Justice Sanjeev Khanna in the Delhi High Court where he chases the full history. Constitution bench, 3 judges, 2 judges, etc. That one judgment. I'm telling. There's also a Bombay High Court judgment, but I will show that separately if required. What happened in this case was that there was a development agreement between 2 parties. The photocopy of that was shown to the collector. The collector said, produce the original, show cause to produce the original, and impound and pay penalty. So, my lord, collector caught hold of the document and said, now you must pay. In that context, my lord, what the High Court does is, the lordship first sees paragraph 15. Section 14, my lord, starts with 33.
Yeah, 62 Supreme Court.
Yeah, 60. My lord, it is 19. We've given the list. 1962 1 SCR.
It's available in 62 Supreme Court.
Yeah.
110.
Yes, my lord. It is quoted, my lord. Paragraph 6 is quoted.
That we just want to see that. Yeah, 62 Supreme Court.
My lord, it is 1962 is the same judgment. 62 1 SCR.
Yes. 110. Yeah.
62 1 SCR. No, whichever one your lordship wants to see. 827. It's the same. Karamchand Thapar. There, my lord.
This argument would apply only if a certified copy is produced, of course. This argument that you are building up on the basis of the scheme, if the original document is produced.
My lord, if the original document is produced, my lord, in the extremely unlikely event that's not.
What will happen in the arbitration if also he produces only the certified copy?
Finished, my lord. The arbitrator will say, I will not go into this at all.
Produce the original.
You will have to produce the original. So, my lord.
How do you admit the document?
My lord, that will be at that. There's no difficulty, my lord. I am not saying Stamp Act will not apply, my lord. I am only postponing, my lord, the event.
Yeah.
One of the last portion.